Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to the webinar where we're discussing laws that protect information. Interesting topic. I want to go through a couple preliminaries here before we jump into the topic itself. First, if you are interested in a copy of the PowerPoint that I'm using, it is available on the Office of Open Records website under the Training tab. There's a tab there with all of the PowerPoints that we use on these webinars, and you're welcome to download them and use them either for your own reference or maybe some internal training with other staff, whatever you see fit to do. If you'd like a copy of the video recording, this session is being recorded, that is available by contacting the Office of Open Records, and they can create a link to a file sharing protocol which would allow you to download the recording. As you are aware, this meeting is facilitated by using the Teams software, and with some of the resources available in the Commonwealth, we can create that link for you. If by some chance that it's not possible to, from your end, to use that link, you can send in a flash drive along with a note and a self-addressed stamped return envelope, and the staff can make a copy of the recording for you and mail it back to you. Usually that option, the turnaround is about a week or so. If you haven't figured this out yet, the format of the webinar is the PowerPoint presentation with me talking in the background. Using the meeting chat feature, you can type in questions as we're going through the presentation, and I'll do my best to respond to your questions as we're going through. But a couple caveats here. First, we are talking about laws that protect information, so try to keep your questions on topic. Occasionally, some folks will, kind of go off on their own script here, and that just makes things awkward. So, stay with the topic, stay with us. Also, I'd ask that you try to keep your questions as brief and succinct as possible. Again, occasionally some folks will type in a couple paragraphs, and it's just awkward for me to sit here and try to go through and read and then respond. If it looks like something is particular to your situation or unusually complex, we'll do one of two things. We'll either wait until the end of the presentation and I'll come back to it, or we'll take the conversation offline. You can, okay, I see someone's having some trouble with the audio. If someone could type in, recommend that they log out and log back in, that usually takes care of the audio on their end. But I'm gathering that most people can hear me speaking. Thank you. Okay, but yeah, if it looks like we're dealing with something specific to your agency or your particular situation, contact the office. They have folks who are trained to try and get you headed in the right direction. They may also put you in touch with me, although that doesn't happen as often as it used to since I'm now in basically a contractor with the office. But we'll help you out. We'll get you headed in the right direction with whatever situation or questions that you might have. I would just ask that today keep your questions on topic and keep them as short as possible so that we can get through them all. Something else that I need to address here is that this presentation is somewhat disjointed, and I apologize for that right from the start. What we did in putting this webinar together is rely on suggestions from agencies, as well as poll our appeals officers for those laws that we encounter here at the Office of Open Records most frequently. Your experience may be different. You may encounter laws that we're not talking about here today that would still have an impact on how you respond to right to know requests. If that's the case, I'm going to ask that you drop us a line because we're interested in the frequency of, how often you encounter some of these other laws that would have an impact on your application of the right to know law. Because if we see changes, we want to update the webinar to make sure that it's relevant to as many of your situations as we can respond to. But for the time being, we're going with what we have. But originally, I think the term is crowdsourced. That's how we put this webinar together based on suggestions. And we realize things change, so we continue to rely on your suggestions to keep all of our webinars as relevant as possible, and we do update them, as the need dictates. So I, thank you for your participation there. And this is really one of our more popular webinars, and I think it's because of the fact that we relied on your input to come up with it. Okay, so all that behind us now, let's jump into the topic itself. As soon as we get things working here. There we go. Okay, why is this important? Why do we need to know about other laws that can impact whether or not you can release records in response to a right to know request? Well, first offhand, the right to know law gives agencies discretion. If you're familiar with the 30 exemptions, there's a common misconception that those exemptions are mandatory, that if a record falls within the definition of one of those 30 exemptions, the agency cannot release those records. But that's the part that's not accurate. The right to know law does give the agency the discretion to release a record, even though it may fall within one of those 30 exemptions. Okay, the right to know law is not a confidentiality law if you've been through that training. Okay, however, if there is another law that says a record is confidential, there is a very good chance that that law removes the discretion that the right to know law would otherwise afford you. And it's even referred to in the right to know law itself with Section 306. Nothing in this act shall supersede or modify the public or non-public nature of a record or document, law or judge's order. Okay, so what that means is that if there is another law or a judge's order that says this record is confidential, you cannot release it, and that law or judge's order supersedes any discretion that the right to know law would otherwise give you. Okay, Ms. Johnson, the list of exemptions is in the law itself. That law can be found on our website under the Right to Know tab. You want to go to section 708B, and then it will list 1 through 30. An exemption is basically a definition of a record that can be withheld, and it's usually several paragraphs. It covers a broad spectrum of records, and when you look at it, common sense would dictate, well, yeah, we would never want to release those. I would suggest also that you sit in on our webinar on basics of the right to know law, where we talk about, not in detail, we don't go into each exemption in detail, but we talk about what exemptions are and how they work. Okay, the other reason that this webinar is important is because under the right to know law, agencies, and that could be, city, boroughs, townships, school districts, authorities, any governmental entity at the state level or local level that falls under the right to know law must bear the burden of proof if they are intent on withholding a record from public disclosure. Now, typically, in meeting your burden, an agency would cite one of these 30 exemptions. However, there may be instances where the exemptions don't cover all of the aspects of the record, and that in fact another law would cover that record. For instance, I'll give you a quick one, and we're going to talk about this in a moment here. For law enforcement agencies, under the right to know law, you could go to section 708B16 for a criminal investigatory record and say that we're not going to release it because B16 applies. However, there's no reference to criminal intelligence information and records in the right to know law. But there is another law called the Criminal History Records Information Act that does cover criminal intelligence, police intelligence information, and police intelligence records. And that law says that they can only be shared with other law enforcement agencies. Okay, so in meeting our burden of proof, we would not necessarily use the right to know law, but we would refer to the appropriate confidentiality provisions within CREA in order to meet our burden of proof to legally show that we will not release these records. And in fact, we cannot release these records because of what CREA says. Remember what I said about discretion. While the right to know law gives you discretion, this example, CREA, does not. In fact, there are criminal sanctions that can be levied for violating CREA. Okay, so that's the other reason why it's important to be aware of these laws. Question has come up. Do you guys rule on CREA, or is that DA common pleas? If an agency, well, let me just, you're ahead of me by one slide. You must have had your second cup of coffee this morning. Okay. If you deny, just to answer your question real quick here, Matthew, if you deny a right to know request by using the confidentiality provisions in CREA, that comes to the Office of Open Records. You would only send an appeal to your district attorney if you're using 708B16, the criminal investigatory exemption, as the basis for your denial. And whether it goes to the DA or whether it comes to the Office of Open Records, the next level of appeal would be your county court of common pleas if it's a local police agency that's initially denying the response. Okay, if it's the state police, then you bypass common pleas and go directly to the Pennsylvania Commonwealth Court. Okay, so let's get over to CREA here. This is the first law we're going to talk about. The Criminal History Records Information Act of 1980, or, we commonly use the acronym CREA. This applies to any person or agency, law enforcement agency, basically, that collects criminal history information. Police departments, prisons, district attorneys, sheriffs, and the courts. CREA protects criminal history, investigatory, and intelligence information, and it can only be shared with other applicable law enforcement agencies. Now, there's a little bit of a footnote here that I want to emphasize. CREA defines what a law enforcement agency is for purposes of CREA. There are other laws that have definitions of law enforcement agencies that would not apply to CREA. For instance, if you're familiar with body cam footage, dash cam footage, security cam footage collected by law enforcement agencies, that's Act 22. Act 22 has a definition of a law enforcement agency that is significantly different than CREA. For instance, this is a little weird, but we've encountered this. Act 22, a school district could be a law enforcement agency. A charter school could be a law enforcement agency. Under CREA, that is not the case. And I always recommend that when someone is trying to figure out how a law works, you always go to the definition section, because here is a good example. Under CREA, the definition of a law enforcement agency is pretty narrow. It's basically, these police departments, prisons, DAs, and so forth. Under Act 22, it's much broader. So you don't want to get the two confused. Okay. So go to the definition section. You'll understand then what a law enforcement agency is considered under CREA. And CREA basically says these records can only be shared among these certified law enforcement agencies. If by chance you would share it outside of that tight circle, you could face criminal sanctions. Now, for further information on CREA, I recommend that you check out the Pennsylvania Attorney General's website, and they have basically a handbook there. That is a very good resource. Download that handbook, and then if you have further questions on CREA, contact the Office of Attorney General because they're the point agency on that, and they'll steer you in the right direction for any other questions that you might have related to CREA and some of the records that the Office of Attorney General oversees. Okay, moving on. Act 30 of 2016, this relates to, for the most part, your county 911 centers. Okay, and under Act 30, they're referred to as public safety answering points. These are your emergency call centers, typically county 911 centers. But for instance, if you have a law enforcement agency that has its own localized dispatch, it would apply to that. And then there are some agencies that have hybrid dispatch. During daylight hours, it's the police department. At 5 p.m., it flips over to the county 911 center. Whatever arrangements your police department has for dispatch, Act 30 of 2016 applies. Act 30 protects individual identifying information of callers, witnesses, and victims. And it's quite common, I've seen it here at the Office of Open Records when I was working here full time, is that someone will submit a right to know request for like a copy of the recording of the 911 call. Well, those records are protected not only by Section 708 B18 of the right to know law, but also by Act 30, where they can't give that information out because it could divulge the names of callers, witnesses, and victims. And specifically, you would not give out the name, the telephone number, or the home address. All this is considered confidential under Act 30. Now, it does not protect the address unless it would compromise any of the above. For instance, if I gave out the address and none of this information, about callers, witnesses, or victims would be divulged, then I could give out the address. And even if it, well, let me just say that typically what I can give out are like block numbers. I'm talking to you today from a building 333 Market Street in the city of Harrisburg. Now, if there were an incident here and you submitted a right to know request, maybe I couldn't give out 333 Market Street, but I could say in the 300 block of Market Street. Or I could say closest to the intersection of 4th and Market Street in Harrisburg. Or if we were out in a more rural area, I could tell you, just pulling this out of my hat, in the at the 32nd.1 mile marker of State Route XYZ, or 123, something like that. Okay, now you may be able to figure out the address just based on that information, but legally, from an Act 30 perspective, I can't give you certain specific information for fear that based on other police reports and so forth, you could figure out who called it in, who witnesses may have been, or who the victims of possible crime may have been. So when you submit a right to know request to your 911 center, it's very limited in what information they can give out. Usually, for purposes of litigation, you can obtain this information primarily through a subpoena that you would speak to your attorney with. The attorney would need to approach the court, get a subpoena, and then use that information for court records, but not through the right to know process. Okay, next one. Attorney-client privilege and attorney work product. Okay, again, changing gears here, but somewhat related. This applies to any attorney and their client where there is an exchange of sensitive information. Okay, and specifically attorney-client privilege and work product, we're talking about uh, uh, legal advice and strategy. And when it comes to agencies, yeah, it's your solicitor or maybe in-house counsel. Um, any communication back and forth because of attorney-client privilege is considered confidential. And in Pennsylvania, it's considered part of the rules of evidence, and it's also referred to specifically in the right to know law in section 305A2. Okay, so there is that reference there in the right to know law. Now, that communication being protected cannot be released to the public. Usually, the more common request or appeal that we see are for legal invoices. And this becomes somewhat subjective because you've got to look at the invoice itself and determine whether or not legal advice or legal strategy can be discerned by looking at the invoice. Now, if your solicitor submits, a monthly or a quarterly invoice that says, for this period, I worked 32 man hours, and that's what I'm charging you for. And that's it, okay? No legal strategy, no legal advice. Clearly, that would be a public record, okay? And sometimes people just want to know what their municipality is paying their solicitor, okay? So that would be a public record. If, however, let's say for purposes of argument, that your solicitor goes into much greater detail. I'm charging you 3 billable hours for legal research that I did on this particular body of law as it relates to litigation that we're currently looking at or that we're currently facing in court next month. I interviewed these potential witnesses, expert witnesses, because I'm considering this defense in the for the legal strategy that I'm going to use in court next month. Okay, if they're going into that level of detail, then there is a very good chance that you could argue that attorney-client privilege or attorney work product applies, and therefore you would withhold these records by claiming attorney-client privilege. Now, that can still be appealed to the Office of Open Records, and they will determine whether or not it in fact applies. From an agency perspective, if you are looking at something like this, what I would recommend is go directly to your solicitor and ask for their insight. Do you think your invoice or this document should be protected by attorney-client privilege? Let them decide for you and then proceed accordingly. And, the requester still has the right to appeal. But, at least if you're an arrow, you're talking to someone with probably a little more knowledge than you about attorney-client privilege, even though it may be their own records. They know the system, they know how it works, and they will more than likely give you an accurate assessment as to whether or not it should be withheld. Really shifting gears here, but this is a common issue that we see coming up in appeals and frequently faced by municipalities, especially when you're dealing with codes enforcement and approval of building permits. And this is the Uniform Construction Code, or commonly referred to as the UCC in Pennsylvania. It's Pennsylvania's statewide building code. And yeah, it applies to any agency that would be possessing building permit applications, plans, or associated records. So yeah, if your municipality is processing, for instance, building permit applications, UCC would apply. Now, it only applies to those structures and applications after 2004. Why? Because that's when Pennsylvania adopted the UCC. Prior to that, Pennsylvania was a patchwork of various codes that would differ from municipality to municipality. I'm old enough to have been around when all this was going down, and you could have one borough that used what was called the Life Safety Code. You go 3 miles down the road, and they would have the BOCA code. I forget what that acronym was, Building something Construction Association. I'm not sure. Then you could go down the road and, you would have a township that used UCC, or maybe they had their own local set of building codes. So for a developer or a contractor, it was a real challenge and very confusing, and it could be difficult to make sure that any work you were doing was up to code because of this patchwork of codes. So Pennsylvania adopted the UCC, which standardized everything. Now, approved building permits in and of themselves are public records. They're not covered by the UCC. But again, the permit application and any associated records are covered by UCC. Now, here's something interesting that you need to be aware of. Uniform Construction Code, you think, only applies typically to commercial structures. All right. However, when you look at the confidentiality provisions within UCC, the language changes, and it's not what it says, but it's what it doesn't say. Suddenly, specific references to commercial disappear, and it refers to basically all construction, which the Office of Open Records, going all the way back to 2012, ruled that, okay, now the confidentiality provisions of UCC also apply to residential structures. So what does this mean? If someone submits a building permit, and let's say they include building plans for a residential structure, a house, the UCC confidentiality provisions allow the agency, the municipality, to withhold building plans for private dwellings. Okay? Think about this. It makes common sense. Why would you otherwise give out building plans to someone's house? But interestingly, there have been a lot of right to know requests or, their neighbors' building plans. All right. That's private. That's confidential. And per common sense, you wouldn't give something like that out. But take a look at that decision if you want to. Ness versus York Township, and I've given you the AP number that you can look up on our website if you'd like to read that. Okay, it goes all the way back 10 years, and it's never been challenged. So if you're an agency Arrow or a codes enforcement officer, you can withhold. In fact, using UCC, you should withhold building plans not only for commercial structures, but for private dwellings. And I think, if push came to shove and it went to court, more than likely the court would apply the constitutional right to privacy in saying that these building plans are not public records. But, until that happens, we're going with our decision back in 2012. And because it's never been challenged, it stands as, legal precedent. Now, let's say that you have a code violation and ultimately legal action is the result. Well, then it becomes a court record and UCC wouldn't apply. In there, under Pennsylvania common law, court records are considered public. So any litigation resulting from a code violation, even if that would include associated records and building plans, could potentially be accessible through those court documents, not through the right to know law. And obviously this would not apply to zoning boards. That's determined by another law called the Municipalities Planning Code, okay, which covers zoning board issues in Pennsylvania. Here we're talking about building code issues. Okay, moving on, and again, changing gears. Now we're going to get into some laws that are healthcare related. And the first one is one that you're probably familiar with, at least the acronym, HIPAA, the Health Insurance Portability and Accountability Act of 1996. Now, for our purposes here with agencies, HIPAA primarily applies to healthcare providers, okay, not municipal governments. However, you have certain municipalities, usually at the county level, that either directly or through a contractual relationship can be defined as a healthcare provider. Usually it's because of their relationship with senior centers within their jurisdiction. Okay, and they have access either directly or through contract to these senior centers that may or may not maintain healthcare records. Probably a better example would be what used to be called the county home. All right, and it would be a senior living center administered by local government. And they have health records. Well, these health records are protected by HIPAA. HIPAA protects individually identifiable health information. So in this setting, it is potential, the potential exists that you could have an employee provide health-related information to an employer, but then the employer must also keep that confidential. So any health-related information from a potential client or patient is kept confidential, as well as any employee-related health information that an employee may voluntarily release to the employer. Okay. More commonly, a more common application, though, for local agencies is the Family Medical Leave Act, or what's called FMLA. This does apply to employers, which could be any agency, city, township, borough, school district, authority, and the like, that could have health-related information for one of its employees. And it would be of particular concern to human resource leave administrators and direct supervisors. FMLA protects any leave or accommodation-related records that could disclose the presence of a serious health condition. Now, let me map this out to you. In a previous career, I was the HR director for a large state agency. And, we had our personnel files that were kept under lock and key. When FMLA came out, we had to go in and separate any leave-related information, any FMLA-related information for accommodations from the personnel jacket, keep them in a separate folder, again, under lock and key, and only our HR leave administrators had access to those files. I was their boss. I was the HR director, and I couldn't even access those records because they were considered, ultra confidential. You could not release this information. Okay, and the leave information was of particular concern because if you're familiar with FMLA, if an employee is absent, if they take 3 consecutive sick days, what happens? Well, typically the leave administrator should be providing the employee with a survey form that is asking them, was this absence due to a serious health condition? If it was, then the leave, in addition to being charged to their sick leave balance, could also be charged to their FMLA leave balance. And under FMLA, you're afforded a certain amount of leave days that can be charged to FMLA during a specific time frame. And, when that's exhausted, certain other things happen, but the FMLA leave needs to be accounted for. The problem for a leave administrator, if someone submits a right to know request, if they want to know how many days leave a public employee is taking, by releasing the leave record, you could potentially be divulging the fact that the employee has a serious health condition. You see how you connect the dots here. 3 consecutive days being charged to FMLA because it is a serious health condition. You've just violated the law. So you need to be very cautious about what, if any, leave information you release concerning a public employee, because the potential exists you could violate FMLA and be subject to criminal sanctions, or at the very least civil sanctions. I forget whether it's criminal or civil for FMLA. So you need to be careful. Now, what if an employee voluntarily divulges, I suffer from a serious health condition? They may do this for the benefit of their employer, to let them know, for instance, I suffer from epileptic seizures, and I want you to be aware of this in case I have a seizure at work, so that you can notify the medical responders, the first responders, that I suffer from epilepsy. Okay. The supervisor can have this information, and they can release it to a first responder on a need-to-know basis, so that if the employee does have a seizure and the first responders are called, the supervisor can say, the employee has notified me that they suffer from epilepsy, just so you're aware of this. And the first responders can proceed as, as needed. Okay. So, 2 things here. The employee can voluntarily divulge it, but then the supervisor and HR staff can only repeat it on a need-to-know basis. And the employee's record of absence could reveal a serious health condition, which in turn would be a violation of FMLA, which you don't want to do. Okay, moving on. Another health-related law that you should be aware of is ADA, the Americans with Disabilities Act. This applies, again, to most employers. So we're talking about most government agencies here. And it protects all medical records and require that they are stored separately from other personnel records. Okay, so when I was talking about HIPAA, yeah, this is the law. Sorry about that. Got a little confused here with the different laws. This is the law that protects all medical records, not just leave, but all medical records, and requires that they be stored separately. Now, what ADA does say here that employers should be aware of, that supervisors should be aware of, is another example where the employee voluntarily divulges a medical condition, and it doesn't necessarily have to be a serious medical condition as defined by FMLA, but any medical condition, where they voluntarily divulge that they suffer from a medical condition, and that is done through a non-medical inquiry. Okay, so here's the example I came up with that I think is fairly common. Let's say that your municipality has its offices in a multi-story building, and you've appointed a fire marshal, okay, a building fire marshal, so that if there is an incident or even a fire drill where you need to evacuate the building, the fire marshal sends out a survey to all employees. Do you have any special needs that we should be aware of so that we can assist you getting out of the building? And the employee says, well, I had hip replacement surgery 2 months ago. I have trouble negotiating stairwells. I need to use the elevator, or I need help getting out of the building. Okay, so in response to that, I don't know, the fire marshal says, you go to the fire tower and you stage on your floor. We'll notify the fire department along with other, employees to ensure that you're evacuated from the building safely. Okay, there, the employee has voluntarily divulged a medical condition based on a non-medical inquiry, the building evacuation plan. All right, so the fire marshal, again, they don't advertise to everybody that so-and-so has hip replacement surgery, although, usually a lot of people know. But nevertheless, legally, the fire marshal has a right to know because of a need-to-know basis. The fire marshal notifies the fire department when they respond because there is a need-to-know basis. They also notify, maybe the fire marshal for the floor, the assistant fire marshal, that John Doe had hip replacement surgery. We want him to stage in the fire tower until he can be evacuated safely. Okay, so you see how all this works. And again, it's all on a need-to-know basis. You don't like write a memo and circulate it to all staff. John Doe had hip replacement surgery. Rather, you only release this information on a need-to-know basis that John Doe is safely and successfully evacuated from the building if we need to do so. All right. Now we're going to shift gears in a big way and go over to a law called Ferpa, the Family Educational Rights and Privacy Act. This primarily applies to educational institutions. So if you're here today and you're from a school district, you already know a lot about Ferpa. If you're here today and let's say you're a parent or a concerned citizen that deals with school districts, chances are you've heard about Ferpa, the Family Educational Rights and Privacy Act. This applies to public and private schools, primary, secondary, and post-secondary. And because of the legal status of charter schools, there is a natural extension that it also applies to charter schools. Ferpa specifically protects individual educational records, which could be report cards, academic transcripts, records of discipline, and the like. Anything related primarily to a student within the academic setting. Now you're thinking, okay, well, what about the sports pages on, the local news website where so-and-so, scored X number of touchdowns? Or what about the honor rolls that they release every quarter? Well, that under FERPA is known as directory information, and school districts are permitted to release that, where they're saying, that basically touting the accomplishments of a student, okay? Now we talk about individual educational records as opposed to aggregated data. Those reports are public. So let's say I submit a right to know request. I want to know the individual scores given out in my son's history class for this test. Okay, that would be individual and covered by FERPA, and the school district could not give out that information. But if I wanted to know what is the mean score for this particular test in my son's history class, if there is a record reflecting that mean score, then it would be considered public. And like all of those reports that school districts need to file with, the Federal Department of Education, with the State Department of Education, those reports that reflect aggregated data typically are considered public records. You would only need to be concerned if there is such detail in the reports that they could be sliced and diced in such a way that would reveal individual educational records. And yes, I've had that discussion with certain school district superintendents, based on requests that they received. So that would be the caveat. If you can slice and dice the data that would make it an individual educational record, then you could, perhaps redact certain information or withhold it. But as a general rule of thumb, aggregated data is considered public. Now, what about parents that are concerned about their child's gosh, what do you call a child of which you are the guardian? But you know what I mean. Okay, what if you want the records for them? Under FERPA, and in general the right to know law, you would not have access. But FERPA does have a specific mechanism for a parent or guardian that supersedes the right to know law. The problem is that many times school districts will deny the right to know request by applying FERPA, but then they don't go the extra step and say, oh, by the way, you can file for this information through this mechanism in FERPA. And, I guess I'm on my soapbox here. If you're with us today from a school district, please make sure you do that, okay? It's just good public service, and it's the right thing to do. Let parents know what their rights are under FERPA so that if they are seeking individual educational records for their child, that they can get them, okay? Off my soapbox. Now, law enforcement agencies, like campus police, okay, FERPA does apply to higher education. So if there is, let's say your student gets into legal trouble, those police reports are treated just as any other police department. Okay, FERPA would not protect those police reports, incident reports. Okay, and just for your own interest, there has been a lot of right to know activity, appeals, legal decisions, primarily from the Pennsylvania Commonwealth Court, providing guidance on access to school videos and how FERPA relates. And I cannot give you any rule of thumb, okay? There's some decisions that fall on FERPA applies, others that fall on FERPA does not apply. I would recommend two sources if you're doing any sort of legal research for this. First is go to our website and do a docket search under the appeals tab on FERPA, maybe on videos and the like, and it will bring up recent cases, how our office has ruled. And if it's been appealed to higher level courts, the links will be there to get those legal decisions. There's also the case law index on our website that you could go in and do a search there that would provide you with specifically the higher court legal decisions. And because they're an index, there are summaries written by our appeals officers that will give you basically the 411 on how the courts reasoned and how they ruled. But I cannot give you a specific rule of thumb saying FERPA applies here, FERPA doesn't apply here. The courts, basically this is a work in progress where the courts still have some work to do in specifically defining. Unfortunately, by the time the courts get around to doing that, probably the technology will have changed, and this isn't going to go away. And then also FERPA does apply to student health records, so that if you do have a school nurse or like a nurse's assistant or something like that, and they have health records on file, they would be considered part of the individual educational record. And you could use FERPA as the means to withhold those records. And just real quick here, I want to finish by saying FERPA applies to educational institutions. Okay, it does not apply to training records that may be held by non-educational institutions like a police department or a fire department or volunteer fire company, because we've had that come up where volunteer fire companies tried to withhold training records by applying FERPA, and that just isn't the case here. All right, as a caveat, the public school code, this just kind of folds naturally into FERPA. It applies to any public school employees and officials. It just reduces, I shouldn't say reduces, but make sure that there's no doubt FERPA applies to schools in Pennsylvania. What's interesting is that the Pennsylvania School Code does expound a little bit more on health records to ensure that health records are considered confidential by making sure that they are specifically referred to in the Pennsylvania School Code. All right, shifting gears once again. Hey, you see what I did here? The Pennsylvania Motor Vehicle Code. This applies to the Department of the Department of Transportation and any agency in possession of driver records. And you could have a local agency, a municipality, that has driver records on file, specifically commercial driver's licenses, because you're required to have those on file if you have employees approved to operate certain types of equipment. Okay, a driver's license under the Pennsylvania Vehicle Code is considered to be an individual's authorization to operate a vehicle. Thus, it is part of the driver's record. And the Vehicle Code protects driver's records. And I've had this discussion with people. They submit a right to know request. Well, what happened in the two instances I specifically dealt with it was you had a citizen who saw one of the public employees operating a big piece of equipment and thinking, is he licensed to do that? Okay, so they submit a right to know request to the borough saying, hey, is so-and-so allowed to operate, that specific piece of equipment? I want to see their CDL, their commercial driver's license. Well, under section 6114 of the Motor Vehicle Code, that's considered private. And the borough used that provision to meet their legal burden to say, you can't release an employee's CDL. And, the CDL is based on a specific piece of equipment or its gross vehicle weight, whatever. All right, but that citizen couldn't see it. So before she filed an appeal, she called the office and I had that discussion explaining to her that, this more than likely, this is how the agency responded. And more than likely, I can't predict how an appeals officer would rule, but I'm sure the agency will use it as their defense. Okay, now, let's say you have a public employee, though, who's got a problem running red lights or maybe driving too fast. And, they end up getting sanctioned, end up getting a bunch of tickets or whatever. Maybe they have a DUI, so they get thrown up in front of court. Well, those are considered court records. And again, under Pennsylvania common law, any legal action taken against an employee for driving infractions would be considered public, and you could get access to those. Okay, next up. Oh, yeah, the federal copyright law of 1976. This comes up fairly frequently, and it's interesting because it involves the intersection of the federal copyright law with various provisions of the right to know law. Question has come up. What about a teaching certification we may have on file? I have a current request asking for a teacher's certifications. Also, they want the date of the certifications, et cetera, et cetera. Okay, I think you would look at, gosh, is it section 708B6? It's either B6 or B9 of the right to know law, where I believe the certifications are considered public records. I am not aware of any provisions within Ferpa, because Ferpa applies to students, not teachers, or the Pennsylvania Education Code that says certifications are confidential. And usually, if you have a public employee, their resume is considered public. Any vitae that may have been used is considered public. Any records that speak to the employee's qualifications are usually considered public. Are officers' training records considered subject to right to know? Helen, I'm assuming you're talking about police officers, but it could be fire officers as well, since you have, some quasi-career fire department officers over there. And I'm going to say yes, unless by releasing those training records, you could potentially put someone in harm's way. Okay, this example, I'm just pulling out of thin air here, but let's say you have an officer or officers who are specifically trained in, I don't know, SWAT, okay, special operations. And, oh boy, let's change it. Let's say use of force protocols, okay? And by knowing that you have an officer who has use of force training, that potentially a criminal could use that to their benefit, then potentially you could withhold those records because the possibility is there you could put someone in harm's way. I'm sorry, I'm kind of thinking on the fly here, coming up with this example, but I think you see the logic. If by showing that an officer has specific training, you could either put that officer or a citizen or victim at risk, you could withhold those records. Okay, but otherwise, training records are considered public. Okay. All right, there you go. You'd have to take a look at it and see whether or not you could use a provision either in CREA or FERPA to see whether or not you could withhold those records. You could probably come up with a better example than I could at this point. Okay, but back to the federal copyright law, because this is an interesting one. Now, you take a look at the copyright law itself. What does it do? Well, it applies to anyone claiming or using intellectual property in the form of authorship. What does that mean from a real life perspective? Usually, you have an engineer or an architect, okay? They will include on any plans or specifications, they'll put a stamp on it. That stamp usually says, I am licensed to generate these specifications or these drawings, okay? It basically says, I can do this in the state of Pennsylvania. Then occasionally, they will include a second stamp, and that's the copyright stamp, where they're saying, oh, and by the way, this plan or these specs are so unique and so wonderful that I am claiming copyright, and I do not want them shared for fear of potential misuse or stealing my intellectual property. Now, for an engineer, that's kind of hard to do because they have to usually follow industry standard specs for anything that they're submitted. So if you have to follow an industry spec, it's hard to claim intellectual property or individual intellectual thought. Okay, but you know, occasionally you see it. So what happens if you do have an engineer, architect, or anybody claiming copyright? Well, the agency in applying the right to know law, and there's a legal decision out there. It is Ali versus the Philadelphia Housing Finance Authority, I think it is. Okay, and it's a decision out of the Pennsylvania Commonwealth Court. Yeah. Oh, I have it written there. Yeah, Philadelphia Housing Finance Authority. Okay, so what that decision says is that if the individual is seeking to inspect the records, which you can do under the right to know law, you can grant that request. However, if they are requesting copies of the records, of the copyrighted records, that would be a violation of the federal copyright law, which would in turn supersede Pennsylvania's right to know law, and that would thus apply. Okay, so if the record is copyrighted, you can inspect it, you just can't have a copy. Now, let's say someone is inspecting and they pull out a cell phone camera and take a picture of the otherwise copyrighted record. The dispute per the federal copyright law is between the person claiming copyright and the person allegedly abusing the copyright. Simply taking a picture is not abusing. And the point being that the agency that has allowed the inspection under the right to know law does not assume any liability, at least under most circumstances, if someone takes a picture in violation of the federal copyright law. It's up to the person claiming copyright to seek legal recourse and any sanctions. Okay, so that explains all that. Okay, some real quick ones here that you may or may not need to be aware of. This one may be more common than you realize. The Child Protective Services Law. This applies to anyone who in the course of their employment comes in contact with children. Now, for a municipality, this would also apply to volunteers that may oversee. And it doesn't happen as often as it used to, but I know it's still out there where a municipality will have like a summer parks program. Or, you know, the school district might have a summer activities program for kids. Okay, so they've got volunteers, they've got employees. They all have to be cleared through Childline, the state system for ensuring that no one has ever been convicted of a crime or any complaints related to child abuse, et cetera, et cetera. All right, so the Child Protective Services Law protects reports, summaries, medical evaluations, file notes, et cetera, concerning any investigation of child abuse. And if you're familiar with the Childline Act, or the Child Protective Services Law, any volunteer or any employee that may suspect child abuse must legally report those suspicions to the appropriate authorities. So you've got a summer parks program, some kid shows up and he's got some injuries that lead you to suspect child abuse. Well, any information related to the reports, the person doing the reporting, and the subsequent investigation are considered confidential and may not be released. I've seen this come up usually when there are child custody issues. And the way that the law works, it can be, from an outsider's perspective, very heavy-handed. It's like, a parent is suddenly caught up in a custody battle and there's a Childline report, child abuse report filed, and they can't get anything. All this is kept highly confidential. It's very frustrating for the parent or parents, and they're filing right to know requests that are being denied. They call our office and you have to explain, basically there's nothing you can do. It becomes very frustrating. Usually I advise them, please, please, please go get an attorney and let them work it out. Yes, it may be expensive, but it's the only recourse you're going to have. Okay, let them work through the system, because the right to know law is not going to get you any of the information you need. All right, but this is the law that protects all of that information. And by the way, if you're dealing with Childline clearances for your employees or volunteers, all of that information is kept confidential as well. The fact that an employee may have been cleared by Childline is considered public, but any of the documentation that was used to receive those clearances are considered confidential under the Child Protective Services Law. Okay, looking at this from another perspective, the Older Adults Protective Services Act, this is rarely applied, but yet we have seen it come up here. And it applies to elder care facilities, again, that either through direct application of services or through a contractual relationship, you've got your area aging senior centers and so forth, where you have an elder care facility. And this law is what protects all reports of abuse or neglect for people above the age of 60 who cannot protect themselves, who are infirmed in some way, that through some sort of physical examination or analysis, this person cannot be their own advocate. So it requires that any employee or administrator that suspects elder abuse, where they see someone who apparently has injuries that could not have been an accident of any sort, they have to file reports, and those reports get investigated. All of that is protected based on the Older Adults Protected Services Act. And finally, they pay me to talk. The Disease Prevention and Control Act of 1955. This applies to the Pennsylvania Department of Health in any of those counties that have their own health boards. Not all counties do. There are also some counties that have consolidated health boards. But it protects reports of diseases, reports of actions, and any other records from release outside those boards of health. Now, I bring this up because this is still a legal issue that is being sorted out as it relates to the release of COVID related records. There were right to know requests filed by various entities seeking aggregated data on COVID-related response rates or infectious rates and so forth. The Department of Health and various county health boards withheld records, claiming that under this law, the Prevention and Control Act of 1955, they were not allowed to give those records out. Thus far, the Office of Open Records overturned those decisions and said aggregated data is considered public. And the courts have upheld the OOR's decisions. There is still court activity working its way through on this issue of whether aggregated data should be released or not. And given resurgence of infectious rates related to, new variants and so forth, I personally don't think this issue is going to go away anytime soon. So, if you're looking for guidance as it relates to receiving a right to know request for COVID-related data, you want to take a look at the most recent court decisions for your guidance. But as a general rule of thumb, thus far, the Office of Open Records and the courts in reviewing OOR's decisions have upheld our decisions that aggregated data is considered public. The legislature, I believe, is looking at revisions to this act or new acts that would supersede it. And, you have the court decisions. So just something to be aware of. And it's probably something that you would want to defer to your solicitors to do the appropriate legal research so that you can respond accordingly. But you should nevertheless be aware that you have this legal activity still developing and probably will continue to develop related to COVID variants and, as we work our way through all of this that's going on. Okay, oh yeah, miscellaneous. Gosh, I almost forgot about this. Just for the good of the order. Common requests that we see, W-2s are considered confidential under the Internal Revenue Service. You receive a right to know request for employees' W-2s. You can say, I'm sorry, we're not giving those out. The IRS makes it illegal to do so. In Pennsylvania, you also have the Taxpayer Bill of Rights, which makes it a misdemeanor to release any confidential tax information. Same way with the Local Tax Enabling Act, or what's called LT. Protects any information obtained from a tax return or investigation of tax returns that would obviously occur at the local level. And then finally, here's an interesting one for you if you weren't aware of it. The Pennsylvania Constitution has been invoked by courts more and more based on language that they refer to known as the constitutional right to privacy. The original decision went back to a right to know case for public school districts and home addresses of school teachers. It has since been steadily expanded by both the courts and the Office of Open Records to include any record that, by applying a common sense standard, you would withhold from public release because of the potential violation of my personal right to privacy. For instance, birth dates, okay? The public can know the month and the year I was born, but they cannot know the day I was born because that could potentially be used for identity theft. And then you've got the B6 provision in the right to know law that would protect, personal phone numbers, my email addresses, and the like. But this is an area of the law that is ever expanding as we run across data elements, I'll call them that could potentially be used or misused by someone receiving this information through the right to know law. Okay, now, yes, we're at the end. I would advise you to take a look at the, Ms. Phillips, home addresses confidential for public employees and supervisors. Yes, they are, as a general rule of thumb. You want to take a look at the law. There is a thing called the balance test, which you would apply where if by applying the balance test, you would say it is in the public interest to release a home address, you would then do so. But that employee has certain rights before you release the address. But as a general rule of thumb, receive a right to know request for public employee home addresses, you would withhold them based on their constitutional right to privacy. Take a look at the law or have your solicitor review the law on it, the case law, to be up to speed on it. Okay, good question. All right, so back to our website, which would include information on releasing home addresses. There is a wealth of resources that you can refer to. And again, if you have any further questions, call the office or email the office and they will get you steered in the right direction. They cannot answer your request for you. They cannot provide you with legal advice, but they can point you to decisions that have been made, 30,000 plus decisions that have been made that may involve similar circumstances to what you're contacting us about. Okay. I want to thank you for your participation today. Hey, it's a hot one out there. It's going to be for the next couple of days. I'm thinking about this because near my house, they're repaving a road, and that's got to be the hottest job in the world as it is. And they're out there now today. I don't even know what the heat index is. Temperatures are supposed to reach, I think, like 94 degrees today. Just stay safe. And, if you're working outside, I hope everything's okay and you're, drinking lots of water and doing firefighters, police officers, road crews, and the like. Take it easy. If you can stay inside and still do your job, please do that. But stay safe out there. Thank you for your participation. Thanks for the good questions today. And we'll see you in 2 weeks when we're doing another of our webinar. In 2 weeks, I think it is the Pennsylvania Sunshine Act. All right, so take care, and we're logging off now, and see you the next time.